Hello everyone, welcome to LNC Pro. This is Ratnesh Parikh, and today in this video we will discuss a very landmark case in depth. SHREYA Singhal versus Union of India. This is a 2012 case. In this case we will see legal provisions that were involved in this case. We will discuss all the sections that are involved in this case that were discussed in this case. We will see facts of the case. Then we will move to the arguments by both the sides. Arguments from the side of petitioner as well as from the side of government. And then we will move to the judgment or the outcome of the case. So let's get started. So these are the provisions that were involved in this case. In this case, Section 66A of IT Act 2000 was involved. Section 69A was involved. IT Rules 2009 were involved. Section 118 Clause D of the Kerala Police Act was also involved, and Article 19, 14 and 21 of Constitution of India were also involved. But Section 66A was the most important section when it comes to this case. So we are also focusing on that section more than other section, and that's what the court did. So let's start. So first of all, I'd like to tell you that this was not one petition. It was a batch of writ petitions, like many writ petitions under Article 32 of the Constitution of India. So the Section 66A of the IT Act was misused by police or the government in many instances. One of the instances I'll tell you that in Mumbai, when the Shiv Sena head Bal Thackeray died, Shiv Sena declared Bandh in Mumbai, and few girls commented on Facebook questioning the reasoning behind the Bandh, and they were arrested under Section 66A of the IT Act. So like this in Kerala and in other parts of the country, this section was misused by the police, and this is how this case came in the court. This case was filed at DU law student SHREYA Singhal. That time she was a law student in Delhi University. So now let's see the provisions one by one that were involved in this case. First of all, this is the most important provision that was involved in this case, Section 66A. This section is a penal provision. So anyone who sends any information or messages using a computer resource or a communication device, if he sends any information or message that is grossly offensive or has menacing character, or which he knows is false, but for the purpose of causing annoyance, inconvenience, danger, insult, out of enmity, all these words are used in this section. These are the words which are very important and which were the reason of controversy. So all this kind of information, if you're sending any information of this kind, whatever the words that are used in this section, if your message or information that comes in all these words, it will be punishable with the imprisonment of a term which may extend to 3 years and with a fine. So this section was misused by the police in a lot of instances. So basically this section was not in the act when the act was originally enacted in the year 2000. This section came by an amendment in 2009. So what were the stance of petitioners? Petitioners contended that this section 66A, it has given rise to new forms of crimes. It is creating new forms of crime, which is very incorrect. And sections 66B and 67C of IPC, they're good enough to deal with all these crimes. So we don't need this section at all. Second point from the side of petitioner was that it is infringing, it is violating our fundamental right, that is freedom of speech and expression, and it is not saved under all those 8 subjects that are covered under the Article 19 Clause 2, as in it is not covered under the exemptions that are given under Article 19 Clause 2. Further, petitioners contended that words that are used in this section, like causing of annoyance, inconvenience, or out of enmity, these are outside of the purview of Article 19 Clause 2. Because 19 Clause 2 doesn't involve these words. and exemption cannot be provided to violate Article 19. So the next thing that they said, which was very important, that was this section suffers from the vice of vagueness. This means this section was ambiguous, because all these terms like enmity or the inconvenience or annoyance, they were not even tried to be defined. Parliament did not try to define those terms, and even if they try, it cannot be defined. So the result of this ambiguity is that very innocent person are also punished because of this section. And this section gives very wide discretionary power to the authorities. For example, I would say, suppose one thing may be causing inconvenience to one person. One person may think that this word is causing inconvenience to me, but other person might not think of that. This is very subjective. This is very a blanket provision. So this is why petitioners contended that this provision should be down. And petitioners also contend that Article 14 and 21 are violated because there is no intelligible differentia. Because this section is applicable only on the medium of internet. So if you are using internet and then you are causing inconvenience to someone, then only this section will apply. By spoken words or written use by other mediums of communication, this section does not apply. So they are saying there is no intelligible differentia, and this is how Article 14 is also violated. And when Article 14 and 19 are violated, this is a triangle, as all of you know. So 21 is automatically violated. So these are the grounds on which petitioners asked for the unconstitutional validity. Like petitioner said, this provision should be declared unconstitutional. So what government said, Tushar Mehta was Additional Solicitor General. He argued from the side of government. He said legislature is in the best position. Legislature is in the best position to understand and appreciate the needs of the people. And this section does not violate fundamental rights at all. And this is why the presumption of validity of this statute should be made by the court. Next section is Section 69A. Section 69A of IT Act, this gave power to the central government to issue directions to block any website from public access. And IT rules 2009 that were also involved in the same thing. So 69A gives power to the government to issue direction, and those directions will be issued under IT rules 2009. An officer will be appointed and he will issue directions as to which website will be should be blocked in which area. So petitioner said the 69A is also unconstitutional because, and it should be struck down because there is no pre-decisional hearing. Before the authority makes a decision that this website should be blocked, there is no opportunity of being heard is given to the parties. According to the government side, government said it is the common practice worldwide. So in the whole world, this is the practice that is happening around the world. This is what intermediaries do generally. And then Section 118 Clause D of the Kerala Police Act was also involved. This section was very similar to the Section 66A of IT Act. As I already told you, this is not one petition in this case. There are a batch of petitions. So in one of those petitions, Section 118 Clause D of the Kerala Police Act was challenged. See, when we read this act, words like causing annoyance or indecent manner, these kinds of words are used, and this is also a penal provision. So validity of this section was also challenged. Now coming to the decision or outcome to the judgment. In this case, Supreme Court held that Section 66A of the IT Act is struck down in its entirety because it is violative of Article 19 Clause 1A, that is freedom of speech and expression, and it is not saved under Article 19 Clause 2, that is exemptions. So that is why Section 66A will be invalid and it will be struck down. The Supreme Court held Section 69A and the IT Rules 2009 as constitutionally valid. And altogether, Supreme Court also struck down Section 118 Clause D of the Kerala Police Act, which was similar to the Section 66A of the IT Act, on the ground that it is also violative of the Article 19 of the Constitution.